Hi, welcome to the last lecture of the course. Thought I would try to speculate some on the future of the politics surrounding the court, and also to talk a little bit about how strong or weak the court is and how our perceptions of the court don't always really capture the nuances that characterize the reality of judicial power. As I talk today, as I do this lecture, we're in the middle of the confirmation process. The hearings haven't started yet for President Trump's nominee, Judge Kavanaugh. And there's a big buildup about what kind of influence this is likely to have. What's the significance of a court becoming conservative again, finally? And so I thought this lecture will address some of the issues relating to that and would give me a chance to at least speculate about the future and see to what extent my impressions of the court will bear fruit in terms of future evidence. But anyway, to begin with, I wanted to make two preliminary points about why it is it's easy to get confused about how influential the court is. The first point goes to our perceptions of the court. And if you look at the incentive structures in American politics, one reason we believe the court is so important is that it's in politicians' interests to tell us how important the court is. When the court makes major decisions and controversial decisions, the court, in effect, takes responsibility for these decisions away from elected officials, even though elected officials quite possibly have significant influence in how the court's decisions come out and whether they're respected and whether they're challenged and things like that. But the simple point is that politicians tell us that the decisions they make regarding the courts, who they appoint to the court, whose nominations they ratify or challenge, politicians tell us that their decisions in these areas are critical to the future of law and the state of the American Constitution and the American Republic. And so to that extent, it's been ingrained in us to think that politics about Supreme Court nominations are incredibly important. And while they're important, I'd like to suggest that the reality of what happens when the court resolves issues about what the Constitution means suggests that there's a lot of other things that are going on as well, and the court's influence might not always be what we think it is. The other point to keep in mind as we go through this discussion about court power and court influence is the distinction between the symbolism of the court's decisions and the practical effects of the court's decisions. Judicial opinions and judicial decisions can have great significance for American constitutional politics, even if they don't change reality all that much. The best example of that, I believe, is Brown versus Board of Education. With Brown, the court seems to radically change American constitutional law, finds a right to attend an integrated school that wasn't there before. The response in the South, the response in the North, suggests great political change occurs when the Brown decision is issued. And I think in terms of the spirit of the country and in terms of how we understood ourselves and the symbolism of the court committing the country to being a principled country, a court that sort of animated the meaning of equality under law or equal protection of the law, that had significance for American constitutional politics. But sort of on the ground, if you look at the rate of integration in Southern schools, it's almost non-existent for 10 years until Congress and the President began to intervene in the politics of education and civil rights. And so the actual influence of the court decision might be much less than we think, and there's a number of reasons for that. And it's to those reasons I now want to look a little bit. Something that we talked about earlier in the course when we talked about Federalist 78 is Alexander Hamilton's statement that recall he's defending judicial review, and he argues that the court is a comparatively weak institution because the court neither has the purse nor the sword. The purse being Congress's ability to legislate and to pass laws that support judicial rulings, and the sword being the president's authority to enforce the court's rulings. And so the court, without those institutional supports from the president and the Congress, can say what the law is. But as in Brown, the effect of the court's statements may not be as great as we think they are. And again, Brown is a beautiful exemplar of this point. 10 years after Brown, things start to change with the civil rights laws of the mid-60s, and those laws empowered the president's ability to sue schools that aren't integrated, and so the sword becomes a more powerful weapon for integrating schools. And Congress also passed funding for schools that are available to schools that did in fact integrate, and so the schools themselves had a new incentive to integrate and could tell the parents in their district that they face a choice: either have less money or integrate the schools. And so that changes the political dynamics at the state level or at the town level. And there's evidence that integration begins to happen slowly at that point, but it begins to happen nonetheless. And so what you see that once the president and Congress support the court's decision, the court's in a greater position to be influential. But the reasons have less to do with the court's power on its own. Rather, it's the ability of other institutions to pursue agendas that interest them by supporting the court, which is a different story. It suggests that the Congress and the president are much more influential here than we would have thought. And I think in the case of integrating schools, that's clearly been the case. Another fact that's interesting to note about the court's influence is we tend to think of the court as a counter-majoritarian institution, an institution that checks democracy, that limits democracy by enforcing rights. The typical way you hear people talk about it is the court's a check against the tyranny of the majority. But the reality, if you look at the court's decisions over time, is that they're seldom out of whack with majority opinion. The court tends to do what the majority wants over time. And so rather than being a counter-majoritarian institution, its decisions in relation to majority opinion seem to suggest that the court is supporting majority opinion rather than undercutting it. Now, that doesn't mean the court's not a powerful institution, but it does suggest that the court's decisions are responding to another power, and that when the court diverges from that other power, it is brought into line, which suggests the court is, again, less influential than what we think. And the examples to think about, or some examples to think about, there are many, but examples that I think are important to note are the Korematsu case, which was the Japanese internment case, in which American citizens of Japanese descent, not Japanese citizens, but American citizens of Japanese descent, were put into camps in what most people today think was a clear violation of their rights. I imagine many people at the time, including some dissenters on the Supreme Court, or at least Justice Jackson, thought that the internment of Japanese citizens of Japanese descent was a violation of constitutional rights. And the court later thought this was a mistake, as did the American political institutions generally. I believe President Clinton apologized to Americans of Japanese descent because of that decision. And what it indicates for the purposes of this discussion is the court going along with a powerful majority. The court is sensitive to rights. The court would be the logical institution to stand up for the rights of citizens at a time when the majority is tyrannizing them, literally. But the court didn't do that. The court instead reinforced the majority. And I think there's a number of reasons why that's the case. On the one hand, the court's dependent on majoritarian institutions for its own power, as we've seen. It needs the president to enforce its rulings. It needs Congress to support its rulings. But a second reason is, I think, tied to the appointment process itself. The people who populate the court tend to be political people who happen to be lawyers. They tend to be lawyers who get the attention of presidents who appoint them, of senators who ratify the nominations. And so these aren't people who are sort of living neutral, nonpartisan lives in the law and then suddenly get involved in politics. They're people who have been involved in politics just through a legal angle, and so they view the law politically. And so you would expect that they reflect those preferences when they act as judges and justices, and that seems to be the case empirically. We seem to find evidence of the fact that judges and judicial opinions aren't diverting so much from the majoritarian institutions, the elected institutions. A second example of the court following the majority, and again it's in an area where the court is supposed to be respecting very particular rights of very small minorities. If you think of criminal justice decisions and the Warren Court particularly, the court made a bold statement trying to enforce a much more rigorous conception of defendant rights. But when the society rejected those decisions, when the society thought the problem of crime is more significant than the rights of defendants, you find that there was a lot of pushback. And once there was pushback, you got, on the one hand, the justices themselves rethinking their arguments in some instances, and also over time you had judicial appointments that reflected a different attitude about crime and defendants' rights. An example of the former would be, an example of judges adjusting on their own would be the death penalty. In 1969, the court didn't declare the death penalty unconstitutional, but it did declare the death penalty unconstitutional as it was currently being implemented, as it was currently being enforced. And there were relatively few executions in the United States in the late 60s, and they were dwindling to a trickle, and people thought that we were coming to a period where the death penalty would die of its own weight. When the court ruled that the death penalty was unconstitutional, again as applied, there was a lot of controversy about that. 2/3 of the states became animated in writing new legislation that had the death penalty. The federal government itself passed a new death penalty law. And suddenly, within 5 years, the court saw a very different political environment and pulled back from its push to overturn the death penalty. And what you find happening starting in 1978, 1979, is the death penalty gets a new vigor and starts to be used again. And the world changed radically, but not in the way that the court in the late 60s would have thought. And there too you see, again, the court following the majority rather than leading the majority to a new place, and certainly not protecting individual rights in a way that's counter to what the majority would want. The one major exception to this notion that the court doesn't stand up to the majority would seem to be the school prayer case, where the court ruled that organized prayer at school in public schools violates the Establishment Clause of the First Amendment. And I think that case had great symbolic importance, and it certainly helped organize and animate conservative organizations that were challenging the court and Republicans who are trying to make the court a wedge issue in order to win supporters from what was then the dominant Democratic coalition of Lyndon Johnson, of the New Deal going back a little bit before that. But one of the things about the school prayer decision is even though the court stood up against a majority, or seemed to, in practical terms, the decision seemed to have much less effect than one would think. Many people have the experience of prayer in schools. It's hard to go to a football game in Texas that doesn't begin, a high school football game in Texas, that doesn't begin with a prayer. And although it's clear that prayer in school is unconstitutional, it's also clear that it's not rigorously enforced, and in order to enforce it, you would have to have somebody to bring another lawsuit to the Supreme Court, eventually to the Supreme Court, but through the appellate courts and the district courts, saying that the schools are organizing prayer in a way that they're not allowed to do. And that happens from time to time. But there are many, 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 many thousands or hundreds of thousands of school districts across the country, maybe more than that. And maybe it's millions. I'm not sure how many school districts there are in the country. And you don't really have support for a program to bring all of these litigations to the court, making it easy for the court's decision to be enforced. In essence, that's what happened to make Brown more powerful, is power was given to the president to bring lawsuits against school districts that violated the principles of Brown. But nothing like that has happened or would happen in response to the school prayer cases. And so the only way for the court's ruling to be enforced is if citizens in the districts themselves bring lawsuits. And that's costly, both in terms of money, and also in terms of just the cost to the people who have to live as kind of scapegoats or outcasts in their towns, because the towns tend to want for there to be prayer in school, especially when they are organizing prayer in school. And you sort of mark yourself as an outsider and bring a lot of cost onto yourself if you challenge that. And so you don't get cases like that. And so the symbolism of the school prayer cases are powerful, or might be powerful, but the practical effect isn't so clearly there. But those considerations speak to the notion of the court being a powerful institution to stand up against majorities. But there aren't that many powerful majorities in the United States to stand up to. The reality of constitutional politics, and really politics generally in the United States, is it's pluralistic. It's minorities forming into temporary minorities, forming into temporary majorities by forming alliances with other minorities. And in those situations where you have coalition building and different groups of interest trying to advance common interests where they can, but having to resolve disagreements about other interests, the court can step in and resolve their differences for them. And to that extent, when we're not sure about things, the court can have a lot more power than we think. Thinking about Brown again, you had a Democratic Party that was an uncomfortable coalition of northern interests and southern interests, of labor interests and farming interests and industrial interests and immigrant interests. And although there were some broad areas where people from this diverse coalition agreed, there were also differences, and certainly civil rights was one of them. The Southerners, who were traditionally in the Democratic Party, disagreed with Northern elites, certainly, about the meaning of integration and civil rights. And when the court resolved the issue, it resolved an issue within the Democratic Party, but it also weakened one limb of the Democratic coalition, one branch of the Democratic coalition, because it's sided with other branches of the coalition. And you tend to see this with controversial cases where the politics gets realigned, but there's really not a majority opinion across a party or across the parties to explain it. And the court really is most powerful when the American people are in disagreement about what it is that they want. Roe versus Wade is an example of that, but that's an example that now crosses the parties rather than is within a party. Though at the time of the decision, there was a strong pro-life presence in the Democratic Party, and so that decision sort of had the effect of polarizing the parties along the dimension of what they think about abortion. But if you think about resistance to the Roe opinion, the court was able to decide Roe the way it did because there was a fairly strong constituency supporting women's right to choose. But it was a minority, not a majority constituency. It was elites in both parties. It was some women. Abortion rights always pulled not as a majority supporting them, but a minority for a long time. And then as we move into the 90s, you start to get, at least with some polls, evidence that a majority supports abortion rights at some level. But the court was able to sustain this decision over time because there was enough political support in the community and in the political institutions to make challenges to the Roe decision problematic. Similarly, if the court today were to overturn Roe, which is also a reasonable possibility, and by reasonable possibility I mean a reasonable likelihood of happening. I'm not sure it's going to happen. I don't even know if I think it's going to happen, but I wouldn't be surprised if it were to happen. But were it to happen, Republicans and conservatives would be in a pretty good position to fend off challenges to the court. If the Democrats captured Congress and tried to fight the opinion, they might make some headway, but because there's a strong political support for the right to restrict, not the right, but the power to restrict abortion, the court's decision would be supported, and it would be really hard to overturn it, at least quickly, at least without appointing new justices to replace the old justices. And practical challenges at the legislative level would be difficult because there's a filibuster in the Senate that would certainly be supported by a minority of senators, but a minority over the 36, I think, or 40 you need to protect a filibuster. There's a good chance you get a pro-life president. There are a lot of institutional mechanisms, a lot of veto points that would make it hard to challenge the court were it to significantly restrict abortion rights. And when you look at the court's controversial rulings, they tend to be examples of a minority, a powerful in a sense both numerically but also in terms of its position in the political process to act against a majority. And so the court has a considerable amount of power to resolve our disagreements when we ourselves can't agree on what it is we want. In other words, when there's no majority, the minority that wins will be aligned with the court in many cases. And that will, at least in the short term, create fairly powerful coalitions until a majority emerges to resolve the issue in a different way. The last thing I'd like to talk about is just a number of issues that are likely to be contested in the court. And what I'm doing is really speculative. Some things are less speculative than others, but I'm assuming that there will be a conservative court. I'm assuming that the conservative coalition we have now that controls the presidency, the both houses of Congress, the Senate and the House, is likely to be short-lived. It seems like one or both houses might turn in the 2018 midterm, but they might not. President Trump seems vulnerable, but the movement we are seeing today, at least, doesn't seem to have the legs of the New Deal or earlier political movements that dominated American politics for generations, even in comparison to the Reagan moment we talked about last period, or in the last lectures. The reason is that the people who are in power it seems pretty clear that they're representing a powerful minority, but a minority nonetheless. And so it would be surprising if that minority expanded to become the kind of coalition that started as powerful majority coalitions, as the New Deal did, and as the Reagan coalition did. But nonetheless, that means it's very likely that you will have a divided society, because those positions, those interests, that coalition isn't going to go away, and they will be able to support their positions through the court now. Now, the issues which I think are most likely to be impacted by this, well, abortion we've spoke about, and I think that the abortion politics will become very interesting now. I mean, should the court actually go through and overturn Roe? I'm not certain that they would, because that would create a firestorm. And frankly, the states have been very successful at putting restrictions on abortion anyway, at least the states that want to restrict abortion. And so the benefits of symbolically overturning Roe versus Wade might not be worth giving up that political advantage from the court's perspective, because as things stand today, it's pretty difficult to get an abortion in a lot of states, in red states in particular. And so the additional abortions that would be stopped with an outright ban might lead to some pragmatism on the part of the swing voters in the new court, but maybe not. I mean, it really actually will just boil down to what Chief Justice Roberts does, as I believe most of the other justices are pretty committed to an anti-Roe position. But again, you never know until the cases play out. But even should the court restrict abortion and say it's not a right and allow the states to put new restrictions on abortion, remember that if the court were to rule that abortion is not, the right to choose to have an abortion is not a protected right, then you would find that states could regulate abortion if they would like to regulate abortion. And you would expect that most blue states wouldn't do that. And so right away, in most of the population centers, abortion rights will be, or abortion access would be the same as it is today. Also, in comparison to, at the time of Roe at least, the ability of people to get from red states and rural areas where abortion is limited to urban areas where it's more likely to be available and people are likely to have access to it, it's challenging, and that's one of the reasons why I think red states have been effective in limiting access to abortion. But still, people who really want to have them will have a way of having them. This is a change, and it will be a significant change, and it will certainly put a huge cost on rural poor and perhaps urban poor in certain areas of the country, and underage urban poor, I think, would be particularly affected in red states. But I also think that socially the issue is very different now, and you would see a very great change in the dynamics of abortion. You'll see people organizing politically differently, and perhaps organizing around themes like the treatment of women generally, and the treatment of mothers generally, and the treatment of children generally. So what the effect of this will be culturally is impossible to know. It's reasonable to think that access to abortion will be more restricted. It's also reasonable to think that the overall number of abortions would change less than people would think they would, and the politics surrounding abortion would change. As I tried to suggest with the death penalty, sometimes when the court gets involved with an issue and pushes hard on an issue, the country doesn't tend to move, but has in the past moved in directions in the opposite way that the court had intended. But again, we won't know until we know. Another area where I think we're likely to see a lot of action in the next political cycles have to do with decisions relating to bureaucratic authority and regulatory authority, and the president's ability to make regulations of certain kinds, particularly in the areas of environment, which with global warming looming as an issue, you'd expect that a very conservative court might handcuff some of the responses to global warming should the political will ever happen to address global warming through the national government in a significant way. I also think something similar might be true with healthcare. One of the issues that has gotten less attention in the last year or two is healthcare costs vis-a-vis a rapidly aging population. And that stew of variables, I think, is likely to make the regulation of healthcare a large issue again. And again, having a conservative court might raise some impediments to progressives' ability to enact and enforce new legislation should they be able to get control of Congress and the presidency again, and the executive again. The last area that I think I'll talk about, or maybe I will quickly add another area. There is something improvised about this. The two issues I would talk about and then finish would be one, executive power generally. We've already seen that President Trump is an unorthodox president and is creating a number of issues about the exercise of executive power. And it's conceivable that in the short term, at least, or the mid-range term, you could see that a number of these decisions, especially if they come down in favor of the president, would see what a continuation of a trend we've already seen, which is the expansion of federal power and an expansion of executive power in particular in the United States. And in some ways, President Trump is just a natural extension or a repetition of many of the presidents we've seen since the New Deal, where power has shifted to the executive, and the society at large and the courts as well have to a significant extent deferred to that. And if that continues, we'll see greater centralization of power in the executive, which is, I think, a reasonable possibility with the combination of this president and this court. The final issue, which may be the most important short-term issue, is the issue of political gerrymandering, with the nomination of Judge Kavanaugh, and should we end up having this nomination ratified by the Senate, which seems very likely, it seems that there's a very good chance that the movement towards rethinking the issue of gerrymandering, and whether political gerrymandering in particular is subject to constitutional review by the court, I think we're going to see a change there. The court had been moving, it seemed, towards the opinion that they would consider the issue of districts that have been gerrymandered to favor Democrats or Republicans. With this appointment, I think they might retreat from that. And as I've said already, we're living at a time where you have a minority presidency. President Trump had fewer popular votes than his opponent, Hillary Clinton, and that was also true of the last Republican president, at least in his first run at the presidency against Al Gore, as we know. And so the demographics are suggesting that the Republican coalition that was closer to a majority coalition with President Reagan, at least in the case of the last two presidents, seemed to be more of a minority coalition. And that same coalition has an electoral advantage in the Senate because of the division of which states are red and which states are blue, and the voting dynamics in red states, which tend to be smaller, rural, and more single-issue states, or fewer issue states than the more populated states. And we've also seen this in the House, where many House districts across the country have been gerrymandered, and most recently by local governments that have been predominantly Republican. And that seems to have had at least some effect in the House of Representatives, where, again, in what seems to be a minority interest on issues like budgetary issues and on issues like immigration, seem to have a voice that goes beyond their numbers. Now, this is going to be contested. It's already being contested by Democrats, and it was being contested in the courts. And one thing I expect you'll see after this is the Democratic Party will be focusing much more on winning local elections where the gerrymandering occurs and resolving it politically should the judicial remedy be taken away, which seems likely to be the case. In any event, that concludes my lectures for this course. I've enjoyed it. Thank you for your attention, and I hope you've gained from them, and I hope to see you in person one of these days. Thanks.